may have mentioned a case from the list, madam. Serial number 43. CRMT, madam. This case may be taken up today at any time.
What is it?
It's for restoration, madam.
Restoration is not urgent.
From the list matter, serial number 27 is the content matter. So the last date, your ladyship, on 11/7, your ladyship will direct to the respondent to hear the side of the petition and then pass an order. It has been 2 months, but she is not being heard. I have given.
Let's see this. We'll just see if that can reach.
Leadership from the list, serial number 37. Content matter leadership. As per order of the Honorable Apex Court leadership, the order of this court was kept in abeyance for 2 months leadership. 7 months have passed leadership, yet the order has not seen any effect till date leadership. May be taken up at any time.
Just wait for some time. Let's see if we are able to reach. Because, I think we will take up these matters very soon.
From supplementary list for local Adat Act 1, second tweet 14 of 2017.
Let this matter be referred to National Local Government. The institute local government.
Item 2, second tweet 262 of 2017.
Same order?
Yes.
Same order.
Item 3, second tweet 334 of 2018.
Same order?
Your Lordship, in this the mediation was successful, Your Lordship, but 3 of the respondents had died, Your Lordship. Their legal heirs have signed the settlement agreement. We have to file a substitution first.
You go to look at that. You find substitute first. Who 3 are? The legal heirs have already
Signed the agreement, Your Lordship. They had come to the mediation center. Subject to that, we can be sent. Subject to the substitution.
When did you file the substitute?
We signed today.
Why are you
Your Lordship.
speaking
They are
about
coming this line. The matter only got Your Lordship settled 2 weeks back. Your
So?
Lordship. The client could not come, Your Lordship, after that. We've got it prepared, Your Lordship. They will come in
Where has the client to come from?
Your Lordship to sign the affidavit.
Where does he stay?
Dunka.
There would be respondent number?
1, 5 and 12. Your Lordship.
All the legal heirs had come to sign?
Yes, Your Lordship. They all had come.
So absolutely it was. Mama, why have you waited for so much of time? We have national local government. It should have been disposed of.
Your Lordship is going to dispose of Your Lordship.
What do you
The
mean?
next-
It can be certainly, but we have a national local government for this purpose.
Your Lordship.
The entire purpose of sending it for mediation was this only.
There's also one practical.
And yes,
Your Lordship, there are many parties, Your Lordship. Few of the parties were very old, Your Lordship. They have signed it, Your Lordship, but if it is referred tomorrow, they will again have to come, all of them, Your Lordship.
you are for the appealant.
Yes, Your Lordship. 41, it has not been admitted, Your Lordship.
That's right. It's not been admitted. But if you want an order from the court, then also you have to file a joint compromise.
Yes, Your Lordship, but on the basis of the report of the litigation,
Then you will have to give consent that it could be disposed of. I do not know. You will not file any joint compromise.
but the mediation report is there, Your Lordship.
On the basis of that, it can be disposed of.
Along with the substitution application, also joint compromise.
But then the respondents, how will they appear? Notice will again go to them. They will again have to appear. You get that? They can always join online before the mediation. Poor, they can't join online. They are poor, they are old. But you are technically sound,
Yes,
right? You are not old, infirm. You can advise them to join online. The centers are there all over Jharkhand. GNC is there everywhere. Essay number 334 of 2018. The learned counsel for the applicant has submitted that. Respondent number 1,
5 and 12.
5 and
12.
12 have expired. When?
One has expired on 22nd May 2023. 5 has expired on 4th September 2017.
5/20.
5 has expired on 4th September 2017. And
4/9/17.
Yes.
And
And respondent number 12 has expired on 20th May 2019.
They have expired on 22/5/23, 4/9/17 and 20/5/2019 respectively. The learned counsel has submitted that at the stage of mediation, all the legal heirs and successors of even these deceased respondents had participated and they were signatories to the mediation. But in absence of substitution, the matter may not be referred for national intervention. There you have to 1 week should be sufficient.
Yes,
1 week. Who is for the respondent?
nobody. Since it's not admitted, so notice is not an issue.
Post on next Thursday. अबेट तो already हो चुका है. उस दिन अबेटमेंट का ऑर्डर करना.
Eight, to your lordship, I'll be honest, your lordship, one of them had died before the judgment also. But
Before the interim judgment.
yes, your lordship, during the course of the mediation, it had come to our notice that they had died, your lordship.
Mediation is सब settle हो गया है.
सब settle हो गया है, your lordship. They had all come. 2-3 जन जिस दिन हो रहा था उस दिन आए, फिर उनको बुलाया गया.
उसको पूरा सरकार ने.
Yes.
What did they agree to?
The shares, your lordship, it was a partition, so all our family members. So the shares, and they had got the agreement first from an army. Based on that, they had agreed on the side.
इसको आप रखें. इसको pending नहीं रखना.
Yes, your lordship, it's settled, your lordship.
Second होने से क्या हुआ? Second अपने notice नहीं हुआ. तो पार्टी appear कराने में आपका जान निकल गया. You have to help them out. DLSC के through notice serve करना है. Telling them कि setting हो गया है, ये कामनामा सब legal aid इधर required. इस तरह से समझो. Otherwise these poor people कहाँ जाएंगे?
कल भी अगर बुलाओगे तो बहुत दिक्कत.
I'm posting it on next Thursday. Do the needful. उसमें लिख देंगे आप कि settle हो चुका है. Like you just write everything in your hand. That settle हो चुका है. ये mediation report you must have got.
No, I'm not going to talk.
But it
Saw
is-
it in the office.
You can put it on record that it has already been settled. There were also parties at the time of settlement, right?
From
From tail list for judgment item 1, second appeal 39 of 1995.
This appeal is dismissed.
Okay.
You knew the result.
उसी में
आज शाम को upload
केस के बाद से पता चल गया
Case
पुराना केस तो खत्म हुआ, कब का था ये?
95
सूट कब का? पता तो चले कि सूट कब?
फाइल लाइन
10 साल पुराना सूट को चलिए।
From tail list case item 3, second appeal 22 of 2003.
This is a plaintiff second appeal against the judgment of impairments. This case has been admitted by this Honorable Court on 14/1/2009 lawsuit. May kindly say order number 9 lawsuit. Whether judgment and decree dismissing the suit on the ground that no personal necessity exists can be sustained in law. Second, whether the question of bona fide personal requirement has been correctly appreciated by the court below lawsuit. Lawsuit, the case of the plaintiff is that
Entirely on bona fide.
bona fide.
The suit was on default and bona
The
fide.
trial court held that during the pendency of this case, one of the tenants, Syam Sundar Henka, vacated the one soap lawsuit, and thereafter he was allotted to Priya Kumar Mato. Therefore, there is no requirement of bona fide requirement. But the learned appellate court lawsuit held that the Jayant Biswas, who is unemployed and he is getting higher education, therefore he did not require the suit premises, and he did not depose before the learned trial court. Yes, therefore the adverse inference has been drawn against the plaintiff lawsuit because the son of the plaintiff did not depose before the learned trial court.
Is there any need?
No need. Lawsuit का judgment हम दिखाएंगे तो no need. The section 114 of the evidence act lawsuit is not a mandatory character. It is a purely directory lawsuit.
Let's see the trial court and
Yes. The issue framed by the learned trial court para 20.
Just a moment. Let's see the case of the plaintiff and the defendant.
Yes.
उसके बिना कुछ
जी
पढ़िए।
para 2 से lawsuit पढ़ रहे हैं.
हाँ।
The brief case, the case of the plaintiff is that
I just want to know, it was only on the ground of personal necessity.
only on the ground of personal necessity.
Under section 14.
Yes. The case of the plaintiff is that when Rama Shankar Tripathi, defendant, was inducted on monthly tenant in the suit premises as mentioned, Schedule A of the plaint, by the husband of the plaintiff number 1, Kamla Biswas, and the plaintiff number 2 to 5 on the monthly rent of 140 per month. Consequent rise in the market rent monthly rent of the tenanted premises was voluntary by the defendant 175 per month from 1/1/1993, then 220 per month from 1/4/1985, and rupees 310 from the time of filing of the present suit. The monthly rent is payable by the first English calendar, and granted acknowledging payment is the book of the defendant. He has paid the monthly rent of 310 till January 1995. The husband of the plaintiff number 1 and father of the plaintiff number 2 to 4 has died on 14/1/1995. Since the death of late Pasupati Biswas, the plaintiff number 2 Satnarayan Biswas is collecting the monthly rent from the defendant, and he is the landlord within the definition of the section 2F of the BBC Act. The plaintiff urgently requires the tenancy premises from starting a ready-made garment business jointly by the Vikas Chandra Biswas, Jayant Biswas, Narendra Biswas, all of whom are unemployed.
इसमें तो इनका नाम नहीं है सत्यनारायण।
Satnarayan. Satnarayan.
नहीं ये ready-made garments
जी
jointly by Vikas Chandra Biswas,
जी
Jayant Biswas,
जी.
Narendra Narayan.
Because they are unemployed lords. They are unemployed.
And Satyanarayan
Satnarayan Biswas is the plaintiff lords who filed the eviction suit lords.
Okay, these three persons.
Yes, unemployed. And their lords suit was decreed lords
Let's kindly read it.
Yes. Shri Vikas Chandra Biswas passed his matriculation examination in the year 1981. Shri Jayant Biswas passed his ISC examination in the year 1989, both of them are sitting idle. Sri Nagendra Ghosh, the second son-in-law of the plaintiff number 1, is also without employment and without any other source of living. They will have to be established in life. They have necessary expertise to start said business, and tenanted premises is on the main road charge and
Is
ideally suit for that purpose. The tenanted premises is reasonable and good faith urgently required for personal occupation for a posted person. The defendant Rama Shankar Tripathi was very much affection of the deceased husband of the plaintiff number 1, Kamla Biswas, is all along aware of a posted necessity and is being urged since the middle of 1988 to vacate 100 tenanted premises in alternative accommodation was also made available to the defendant just by side of the tenanted premises on the main road. And on behalf of the plaintiff family, where the defendant has started a cloth business under the name and style of punctuality in the name of his family member, but he was put off vacating the premises on various pretexts as such plaintiff number so and sons were since 1982 to fulfill his promise, and he has adopted means to file the false report before the police. The sons of plaintiff number 1 and finally defendant has refused to vacate the premises. The defendant appeared on 4/5/1992 in this suit, filed a affidavit seeking the permission to contest the suit, and he was formulated to contest the suit. The filed the written statement on 27/5/1995. The defendant stated in his written statement that there is no cause of action for the suit. The suit as framed is not maintainable. The defendant has also denied the relationship of landlord and tenant between the plaintiff and defendant. The defendant has never paid any rent to the plaintiff, and he did not. The plaintiff ever claimed or demanded the rent in the respect of suit premises from the defendant, nor did the defendant ever
Come to para 14.
para 14. It is also stated by the defendant that after death of said Pasupati Biswas, his fourth son is Satnarayan Biswas, Vikas Chandra Biswas represented themselves to be the exclusive heirs of the late Pasupati Biswas, and Mala Dev Biswas would collect the rent from the defendant in respect of said premises. Only in his absence, some other one of them will collect the rent from the defendant. They has their mother, the defendant also denied the defendant number 1, Kamla Biswas, or she ever was the landlord. Yes.
Para 16.
The defendant also stated in written statement that Jain Biswas is a student of BSc in RS Mahavidyalaya, Chas, Bokaro. Being number so and so, he is prosecuting his set of Syrian, and he is not sitting idle of the alleged. He does not require the suit premises, few any businesses, whatsoever. Because of Biswas is neither the unemployed nor sitting the idle. He is working as a daily passenger. He is easy of his business of order supply. He bring the materials of the customer at their order and supported to them. Supplied to them, and for that service he received remuneration by way of his commission on the value of goods, and orally agreed between him and buyer is carrying well, and he has taken of Jain Biswas instead.
He's taking the assistance of Jain.
During the pendency of the suit, after filing the written statement, defendant Sri Vikas Chandra Biswas has joined by service Bokaro Steel Limited on 18/7/19. As such, also he is not idle and unemployed and does not rent the suit premises bona fide and his good faith for his own use and occupation. Jain Biswas is a student of BSc. During the pendency of the case, Jain Biswas got admission in CWA course in Bokaro Steel City. The cost of accountant of Sector 2 Middle School by registration number so and so. After taking regular 1 year coaching, appeared in intermediate examination of said seat as Calcutta held in December 1993 and June 1994, and his requirements is valid up to 7 years since 2 days of registration. He also applied to Ranchi University for admission in MSc. As such, he is not idle and unemployed at any point of time. The defendant is not only any business under name and style of punctuality alleged by the defendant brother in favor of the said business. Defendant also denied that he lodged any false report with the charge police station. Sri Madhav Chandra Biswas, who used to collect the rent in respect to the suit. Fine. Issue में आ रहा है लॉर्ड्स, issue 24 लॉर्ड्स. 24. The main issue is that issue number 4 is there is a relationship of landlord or tenant between the plaintiff and defendant. The learned trial court held that there is a relationship.
No, there is no problem.
Yes. 5 is the
Number 6.
6. Whether the plaintiff requires the tenanted premises
Where is the
renewal
final
as good faith
justification?
for a starting business law.
Where is the finding?
Fine is 32 losses. 32. 32.
52.
जी.
52 बोल के तो कोई पेज नहीं.
नहीं 12 32 लॉर्ड्स. 12 32. Issue number 6. हाँ.
Yes, please.
Yes. Issue number 6. The suit was instituted for eviction of the defendant from the suit premises and starting any government business by Narendra Narayan Ghosh, Prakash Chandra Biswas and Jail Biswas, and the lawyer of the defendant argued that Sri Narendra Narayan Ghosh, son-in-law of the plaintiff, is the resident of village so-and-so, is fully occupied and cultivation is family land and he is not unemployed. He is also not the member of the Biswas family. P.W. Satnarayan Biswas and P.W. Vikas Chandra Biswas admitted this fact in examination that Sri Narendra Narayan Ghosh is the resident of village Jhalda, Pulia, and he is respected person having the property at the place. He introduced the grain for food only for 6 months. On the other hand, Sri Rama Shankar Tripathi, the defendant number 1, says in para 17 of the written statement that Sri Narendra Nath Ghosh, son-in-law of Sri Pasupati Biswas, who is the resident of Khosla, P.O. Jhalda, Pulia. He is not living with the Biswas family of the charge. He has sufficient property and engaged in agriculture. Exhibit 1, the voucher list also proved that he is the resident of Bokaro, Pulia. He cannot be defined as a family member of Biswas. As regards Sri Vikas Chandra Biswas, learned lawyer submitted that he is neither unemployed nor sitting idle, nor he is permanent employee.
Now he is permanent.
Yes, Bokaro Steel Plant, and he is daily passenger and he is carrying on his business of the order supplied the same them and for the service of received his remuneration on by way of his commission on the value of good. During the pendency of Sri Vikas Chandra Biswas joined the service in Bokaro Steel City in Khalasi on 18/7/1999. Later on, he was made permanent in Bokaro Steel City on steel. Nothing. The soap number so exhibit J relevant paper which proved that Sri Vikas Chandra Biswas was appointed on temporary. Khalasi was made permanent in Bokaro Steel City and he was made permanent lower court. Now he has no requirement of suit for his own use and occupation for personal necessity. The learned lawyer for the plaintiff did not prove the need of the Vikas Chandra Biswas. As regard the Jain, this is important also. As regard the Jain Biswas, the lawyer for the defendant argued that he is the student of BSc in RS Mahavidyalay, charged during the pendency of suit. Sri Jain Biswas got admission in ICW 1 course in Bokaro Steel Coast accordingly Sector 2. After taking required 1 year's coaching, plan appeared in intermediate examination ICW course of Kolkata held on 1994 and registration valid up till 7 years. During the BSc, he appears for admission in MSc in Ranchi College, Ranchi University. He also got admission in PQ Memorial College, Dhanbad. As such, he is not sitting idle and unemployed at any time, 7 the day of the institution of the case. Yes, same the day. 13. Rama Shankar Tripathi, defendant, witness number 4, in para 4 said that Jain Biswas is the regular student of college engaged in the study. Exhibit E. C. Abstract carbon copy of the request of the statement corrected for tuition. Exhibit D. for oral coaching administration form of application for enrollment. Exhibit E, page number 236 is the list of the make list of in the year 1993. Exhibit 1, page 14, 17 of cross list of the mark sheet for year 1995. Wherever appears the Jain Biswas is the student and continue this study. The plaintiff lawyer appeared and the defendant said that the Jain Biswas passing BSc examination was changeable for admission in MSc course in the year 1992-1994, which did not continue. Later on his case, he was again considered for admission process in 1993-1995. Thoreau educated in college in Dhambad, but in absence of the hostel accommodation and other reason, he is not interested to continue the study and has withdrawn from the college and continue for full law in business and sitting idle. He is awaiting if he want to start permanent business in the suit premises. PW Vikas Chand Biswas in para 17 of his cross examination said that Jain Biswas has made preparation of his examination. PW1 Satnarayan Biswas stated in examination institution Jain Biswas has completed his part-time course in NEET Bokaro Center of Advanced Diploma Software Technology and System Management. Exhibit 3, he has completed his NEET course of BSc, and Sri Satnarayan Biswas PW1 has also stated that he is not necessity to examine in Jain Biswas. On the other hand, the DW4 Ramasankar Tripathi has stated in cross examination that after completing the diploma course in computer education, Jain Biswas has taken admission in NEET course and continuing his computer study. I also feel that Sri Jain Biswas be the best person to say that he is not studying.
He is doing this course. Also that he has already completed Exhibit 3.
He has completed, but he is still unemployed.
That's right. This is what
yes, he is unemployed. Mere getting the higher education cannot be said to be employment, Lords. Para 36. During the course of the argument, the learned counsel for the plaintiff has stated that suit premises are urgently required for starting a business by grandson of the plaintiff number 1 and son of the plaintiff number 2. Sri Jain Biswas and tenanted premises also used that alternative accommodation also made available to defendant just by the side of the tenanted premises on the main road charge on behalf of the plaintiff family, where the defendant has started a cloth business under the name and style of the Panchvati in the name of his family law. But he was put off vacating the premises on various pretexts when the plaintiff's son were giving defendant in the month of February 1992 fulfill the promise that he had made false report before the police station. Plaintiff number 1 is to give up their urgent necessity, and finally the defendant has vacated the suit premises and sought to file this suit. PW1 Satnarayan Biswas and PW2 Vikas Chandra Biswas supported the version of the plaintiff in their examination in chief. DW2 Kamal Shankar Tripathi stated in examination that he has taken a soap in rent from Kali Padu Das. In that soap, he has started a business of cloth merchant, who also exhibited the registration. Exhibit B, never the Panchvati and properly of the Sri Ramasankar Tripathi, the owner of the soap, where the Panchvati is joining in different person, namely Kali Padu Das, and plaintiff failed to establish that soap in which the Panchvati running believed the plaintiff family was offered by the plaintiff as alternative accommodation.
There was a vacancy, but still you let out.
Yes.
Right? When you were in need of a shop, you started business.
Lordship, during the pendency, because one of the tenants was vacated, Sam Sundar Henkar, Lordship.
Yes.
And he allotted to Priya Kumar Mahato.
No, he did not allow. It was allotted by Satnarayan Biswas.
Satnarayan Biswas, but it is the choice of the which premises is suitable to the.
Where was this premises located?
Charles, Lordship.
Where, same place?
Same place, Lordship.
So why did he let it out?
Lordship, the sub premises is suitable for the plaintiff, Lordship.
Suitable means what?
It is a suitable
It was
for
already a garment shop.
already a government servant, but the Jayant Biswas is still unemployed, Lordship. He is still unemployed, Lordship.
So why did he let it out?
Lordship, but because the suit primacy is suitable for the
From where do you say this?
plaintiff, Lordship.
From where do you say
But
this?
law is well settled, Lordship. May kindly see section.
The suitability is, we have to see the suitability, right? These witnesses were cross-examined on the point of this or not?
Yes.
Any witness was cross-examined on the point of this letting out by Satyanarayan Vishwas?
No, not cross-examined by Lordship.
From where is it coming? From where it is coming? Somebody must have said.
Yes, somebody must have said, Lordship.
Who has said? Some witness
Yes,
must
somebody
have
must
said
have said, Lordship.
before the court.
Yes.
Was that witness cross-examined on this point?
No, it was not cross-examined by the. It was not cross-examined by the Lordship.
Very happy.
In para 37, after remand of the case, as per the one of the tenant of plaintiff Shyam Sundar Henka, who carried on business under the said style Parivar government in soap side supremacy, vacated the same Satyanarayan Vishwas out of search in raid to Priya Kumar Mato and let go. Sri Priya Kumar Mato is carrying on his new ready-made garment soap and name and style so and so under the valid license number so and so. Under the Bihar Soap and Establishment Act, DW4 Ramas.
Yes.
DW4 Rama Shankar Tripathi supported this fact. The further examination in chief, he said that soap of the plaintiff running by Sri Shyam Sundar Henka was vacated by him and he was let out to Sri Priya Kumar Mahato on higher rent. The defendant has examined Sri Shyam Sundar Henka as a defendant witness. Shyam Sundar Henka filed a petition before the Deputy Labour Commissioner after for cancellation of election and for shifting the premises. The application filed by the Shyam Sundar Henka was called for on 3 after 3. The Deputy Labour Commissioner Bokaro Sri Henka also stated in his chief shall be concerned on business under the name and style of the Parivar government and the license number so at charge. The application filed by the Shyam Sundar Henka is marked exhibit, and if the plaintiff denied the said that these papers are manufactured, but still is no reason to dispute the exhibit O and disbelieve the exhibit O and exhibit O by A. And license of Parivar government also cancelled compared to authorities original regular under the chief shop establishment act and also called for from the labor other Bokaro which is exhibited exhibit M and exhibit M and N. The defendant also stated the shop vacated by Shyam Sundar Henka was also let out to Priya Kumar Mahato and said Priya Kumar Mahato started the business under the name and style of PM government. The government community was denied this fact. Also filed a photocopy of the counterfile of the rent receipt. Sri Shyam Sundar Henka admitted his signature mark exhibit so and so so and so. The plaintiff also stated that the original counterfile were kept of the tenant. So these photocopies were filed. Also stated that information to police also, but plaintiff failed to file the information to police any paper through which it can be sued. He said that he usually issued the report receipt. In such circumstances, the theory of photocopy cannot be believed. The register of the funds under the Bihar Shops and Establishment Act under Form 2, Rule 3 shows that a firm MSPM garment named or charge was registered by Sri Priya Kumar Mahato. The PUN book is also exhibited through which notice of the department was served to Sri Priya Kumar Mahato. Notice was received by Priya Kumar exhibit Q by 1. The notice was also called for the department and exhibited. Denied that this fact any soap was vacated during the pendency and was let out to Sri Priya Kumar Mahato. Papers produced by the office of the Deputy Labour Commissioner Bokaro were manufactured, but the contents of the plaintiff were not tenable and papers of the labour after cannot be said to be manufactured. And I came to conclusion during the pendency one soap vacated by Shyam Sundar Henka and was let out to Priya Kumar Mahato in which they are running PM government. The learned lawyer of the plaintiff has referred so and so decision I am skipping also. That also refer another principle laid down in so and so should meet the principle laid down by the as discussed above. It is established that during the pendency, one soap of the plaintiff was vacated by Syam Sundar Hemka and soap was let out to Sri Priyag Kumar Mahato. In the present circumstance, I feel the need the plaintiff to grant a new person. He started his business to let out to an person is not bona fide independent. Also, refer the principle laid down in 1982 BHJ 19 in which the
That's
application.
right. The court recorded a finding that the requirement is not bona fide.
No, only on the ground that Jan Biswas is getting the higher education.
No, that is not the ground. The ground is that a shop premises was evicted, right, in which garment shop was running. In spite of that, another person.
But the
was
Jan
indicted.
Biswas is still unemployed, Lord.
Maybe. Even if he is unemployed, it means that he never wanted to work.
No, he want to start a business.
He wanted to start his business, he wanted to start a garment business.
Never came to
A garment business shop was vacated, but still he let out to somebody else.
But
It means the very fact-
which is not suitable for the.
From where do you say it is not
But
suitable?
it is law say there, Lordship. I will refer the law,
Then
Lordship.
you should have cross-examined.
Whether I am said or not, which is immaterial, Lordship. The section 11 explanation to Lordship may kindly see.
We'll see that. Appellate court.
Yes. Appellate court, Lordship. Para 13, Lordship, point for determination. Para 13, Lordship. Whether the requirement of tenancy suit premises existed reasonable and bona fide to the plaintiff, whether the appellant plaintiff let out the adjusted vacated soap to one Priyag Mahato during the pendency of the suit, this entitling him to get the decree on the ground of bona fide requirement. The findings point number 1, Lordship, para 14, Lordship. So far as need of the plaintiff, number 5, because of the Biswas is concerned, it is admitted by the counsel of the appellants and further proved by Exhibit J that the service in DSL has been made permanent. As regard the requirement of Jayant Biswas, grandson of the plaintiff is concerned, the learned court below negativated his claim on the basis that he is engaged in NEET course after NEET in June 1997 and not idle and unemployed. Further, it is opined that Jayant Biswas himself would have been the best person to testify. He is not studying and sitting idle as an unemployed, but the plaintiff has failed to examine him. According to plaintiff, at the time institution of Jayant Biswas passed ISC, PW1, father of the Jayant Biswas has deposed that his son completed BSc in 1994, has not studied in MSc, even after getting admission in Institute of Joint NEET course, which has completed in June 1997, and certificate filed as Exhibit 3 since June 1997. Jayant is completely unemployed and sitting idle. It is also to be recalled that during the pendency of the civil revision number so and so before the Honorable High Court at Ranchi bench, the defendant petitioner filed a supplementary affidavit that Jayant Biswas has been engaged in NEET course, not sitting idle, and it was remanded to decide the point. After remand, both the parties were reduced their oral and documentary evidence. PW1 Sri Satyanarayan Biswas, father of the Jayant Biswas, on recall dated 16/1/1998, deposed that his son, after completing BSc in 1994, joined NEET instead of studying in MSc after getting the admission. Further, Jayant completed NEET course in the year 1997. A certificate of it is marked Exhibit 3 with objection by the defendant. We show that Jayant Biswas has undergone in part-time advanced diploma software course, another half years course in NEET, Bokaro Center, Delhi, 2 hours from the 5 p.m. to 7 p.m. and completed the course in June 1997. On the other hand, the defendant Rama Shankar Tripathi, on recall after remand dated 17/4/19, has deposed Jayant Biswas engaged in NEET after completion of the NEET course. He has taken admission in the year 1994. The requisition is valid up to 1999. He never remained idle since the institution of the suit is still the study and does not require engage in the business. Defendant has examined DW53 Sanjay Kumar, accountant Bokaro Meat Center. He reports that in pursuance of summon issued by the court, he has brought the details of the course in which then this was took admission prosecuting a study and present position of the study. This witness has stated since the Jain this was not continuing the study, his certificate of ATM Exhibit 3 has been brought by him at para 5. This witness has stated that Jain Biswas is not studying as present in the institution as per the record and personal knowledge of the witnesses. On the basis of the above evidence report, it be concluded that Jain Biswas has not engaged in any study since June 1997 for NEET course, which is supported by evidence DW4. It is noted the plaintiff at the time institution of the suit claimed the requirement of opening of shop of ready-made garment with 3%, but now taking into consideration the further development during the pendency of the suit, the requirement now exists only in favor of the Jayant Biswas, who is unemployed and idle. As per the plaintiff, the father of the Jayant Biswas has deposed that the suit premises is required now for the business of the Jayant Biswas. Therefore, requirement of suit premises has not legally been clear. He is to be considered the BBC Act contemplates not only requirement but the requirement of persons must be reasonably bona fide. PW1 Satnarayan Biswas, the father of the Jain Biswas, has deposed in para 5 that his son has good academic career and he is major and desirous of entering into business and NEET course may be utilized in any type of business. The witness has further deposed that he does not feel necessary to produce his son as a witness. As in regard to the above statement of the plaintiff number 2, it is not clear that what type of the business Jain Biswas is desired to start business and suit premises fit for business purpose or not. In my considered view, the Jain Biswas, those businesses
For whose business?
for whose business the suit premises is required could have deposed in the court.
What your case was that you wanted to start this
Ready-made
garment business.
ready-made
That was a
garment.
throughout case.
Yes, ready-made
Throughout
garment.
that was a case.
Yes. Voluntary. If such vital evidence could not production of the important division, I said the adverse inference can be drawn against the plaintiff that if the Jain Biswas would have been examined, the state of the facts would have been otherwise. Under such, I do not find that the requirement on the ground of personal necessity of the plaintiff is reasonably bona fide in the light of further development in this case. The point number 2. The defendant during the pendency of the suit put forward new development by way of an amendment in WS, stating here that adjacent to the suit premises scope of the plaintiff, equal dimensions to the suit premises were run by the tenant Shyam Sundar Henka, son of Sri
When
Manohar.
was it evicted?
Shyam Sundar Henka.
When did he evict?
Shyam Sundar Henka. So here has not been mentioned also. Judgment of the learned trial. During the pendency, it has been mentioned during the pendency of the suit also.
When did Jain complete his course? Exhibit 3, what is the date of completion?
1997.
1997 he completed this course.
It has been mentioned that the joint NEET course which has completed in June
Exactly.
1997.
June 97.
Yes, it has been mentioned by the.
The premises was vacated in 1998.
Yes,
So after 1997, when the premises was vacated in 1998, he did not take the opportunity to use it, and he let it out to somebody else.
yes, because you
Even
know,
this finding has been recorded against you. So both the findings are recorded against you.
both the finding recorded, but it is not suitable for the plaintiff.
From where do you say this?
Lord, we-
355. इन्होंने अपने एडिशनल रिटन स्टेटमेंट फाइल किया था,
जी,
आपने उसका जवाब फाइल किया होगा ना कि सूटेबल नहीं है.
Lord, sir.
ये admitted the point.
para 13 of the learned first appeal court judgment of the Lord's mechanism.
Para 13.
Yes. In middle line, Lord, the father of the Jain Biswas, Lord, has deposed a para 5 that has your lordship got. Yes. The father of the Jain Biswas has deposed a para 5 that his son has good academic career and major and desires of entering into the business and NEET course may be utilized in any type of business. It has been mentioned. It has been mentioned, Lord.
If it can be utilized for any type of business, why did you use the shop which was vacated?
It is not suitable for us.
From where do you get this? That it was
Lord,
not suitable.
Lord, the law is well settled. May kindly say section 11.
The law is well settled and suitable.
Lord,
But they filed additional written statement taking this plea. Did you respond to that?
I am the plaintiff. No,
Additional
filed the
written
additional
statement
written
was
statement,
filed.
Lordship.
They filed additional plaintiff.
Plaintiff. The defendant is also running a.
The defendant amended the written statement. Did you respond to it?
I have to.
ऑर्डर शीट में दिख रहा है कि आपने कुछ रेप्लिका भी फाइल किया था,
जी,
आपने उसका जवाब फाइल किया था, वेयर इज दैट?
I am also searching. I got the amended written statement, but I don't have the copy of it.
The amended written statement is here.
Yes, I have gone through it.
Yes. What is your reply to that? Did you respond to that? After all, you have to say before the court in your pleadings that this is not required. This is not suitable for me. At least that pleading has to be there. In absence of that foundational pleading, how can you just argue that it is not suitable for you? Yes.
Not chemically section 11 also of the explanation 2 of the BBC Act also. Explanation 2 also.
Section 11, explanation 2.
Explanation where there are two or more premises let out by the landlord. It will be the landlord to choose which would be preferable to him, and tenant or tenants shall not be allowed to question such premises.
Yes.
But the suit
If
premise,
there are two tenants, so the one tenant cannot say that why has he not filed eviction against the other. Fair enough.
yes,
But when there is already a vacant premises available, and they amended the written statement pursuant thereto, that this is the vacant premises available which they could have occupied, and therefore, and in spite of that they have let it out, therefore the need is not bona fide. So,
but my case is only it is not suitable for the plaintiff lordship.
you see, when you say that it is not suitable, there has to be some foundation to it. There is no foundation, neither in the pleading nor in the evidence.
Yes,
Show me something that it is not suitable. Show me any argument that it is not suitable. There is no argument also to that effect. Rather, you were throughout denying that there was no premises available. It was never your argument.
para 11 of the plaintiff lordship. Para 11.
This 11.
The tenanted premises on the main road charge and ideally suited for this purpose, Lord.
For that purpose.
So,
And Lordship, that purpose is para 7, Your Lordship. Kindly see.
eviction suit 6. Para 11 is something else. Just a moment.
It is mentioned, Lordship, suited for this purpose, for starting a business, Lordship.
For that purpose, Your Lordship.
Just a moment.
That the para 12 also the aforesaid person, one of whom is also co-owner of the tenanted premises, as such, tenanted premises is reasonable and good faith urgently required for personal occupation and for the aforesaid purpose.
This was the situation when no other premises was available.
Your Lordship, may I intervene? Para 7, kindly see.
Para 7.
Your Lordship, of the plaint. What is that purpose? That purpose is for the starting of ready-made garments business.
Yes, that's
Your
true.
Lordship.
And a shop it was existing for ready-made garment was vacated.
Your Lordship.
But
From where do you get this?
but
From
there
where
is
do we get this?
there is a specific pleading, Lordship, in
There
my
is
plan.
when you file the suit, right? At that point of time, no other premises was there. And then you said that you are filing an eviction suit against this tenant because you feel that this is the most suitable premises for eviction, for this garment business. In the meantime, at the stage of High Court or whatever was the stage, one of the premises of your tenant that was vacated. Now the High Court remanded the matter for consideration.
Yes.
They amended the written statement, saying that this premises was available, but they did not utilize it, and therefore there is no bona fide requirement. This conduct indicates that there is no bona fide requirement. Did you file any response to that?
Lordship,
Your entire case was that there were no premises that he never vacated.
रिटर्न स्टेटमेंट में कोई रिप्लाई नहीं फाइल होता है सो
नहीं फाइल क्या होता है अगर मान लीजिए कोई अमेंडमेंट करता है if anybody is filing an amendment to the written
if the amendment
statement
is made by the plaintiff lordship
No,
then
no,
the
if the-
defendant
if
has
the-
a right to file the additional written statement but so far as the amendment of the written statement lordship I cannot file anything lordship I will
If the-
vote only evidence lordship.
okay. So what is your evidence that that particular premises was not suitable? At least any cross examination on this?
But there is a pleading 11 and 12 of the plaintiff lordship.
यही आपका आंसर है Something must be there that it is not suitable for you. Who was examined after demand? Who was called on recall? PW1? कौन आए थे recall? PW4. Who had appeared on recall? Who had appeared on recall?
DW4.
Plaintiff without supervision.
Para 39 is also a register of form under the Bihar Shop and Establishment Act under the form number 2, 3 saw that for Mrs. PM Garment Railroad Charles was registered.
Just a minute. of the judgment.
Your Lordship, of the trial for judgment. The register of form under the Bihar Shop and Establishment Act under the form number 223 shows that form Mrs. PM government may not charge was registered to Sri Priya Kumar Mutto. The Pium book is also exhibited, which the notice of the department was served to Sri Priya Kumar Mutto. The notice was received by said Priya Mutto, exhibit Q1. The notice was also called for from the department and established as exhibit R. The plaintiff has denied this fact that any shop was
कोई cross
vacated.
examination नहीं, कोई cross examination. Rather we were totally denying कि वो खाली नहीं किया नहीं किया. PW4 ने अपने chief में when he again appeared on 5/1/2001, DW4.
Yes.
He said that one shop was vacated and भाड़े में दे दिया. लेने के बाद रेडीमेड की दुकान किया, वह दुकान अभी भी चल रही है, प्रयाग में तो चला रहा है. इस पर कोई क्रॉस एग्जामिनेशन that this premises is not suitable. Rather you have cross examined कि ये तो 1996 से ही बंद पड़ा. This is the cross examination. Then under such circumstances, how can you say? You will not even cross examine anybody.
But
Neither there is any pleading that this is not
pleading
just
is
a moment.
pleading is there.
Just neither there is any pleading that this particular premises is not suitable.
It
Because
has been it is
this
suited for the
This happened during the pendency of the case, right?
yes.
अगर मान लीजिए अगर कोई और premises के खाली होने का कोई relevancy नहीं था, तो why the High Court has remanded the matter to only to find out whether this particular premises was vacated and further whether this particular premises was suitable. Both the things were to be examined. DW4 when he appeared before the court, he said about this premises, there is no cross-examination. There is no material to show that this is not suitable. They had amended their written statement specifically to this effect. कुछ है ही नहीं. DW4 का तो ये है. Think, just have a look.
No, I have seen it.
You have seen it?
Yes.
आपको तो पता ही है.
But I am relying for judgment.
Judgment आपको दे देना है.
Only one point added.
Just one. Let him complete.
2025 SCCR latest judgment of the Supreme Court
Yes.
270 para 10 votes. बता.
Para number sorry.
Para 10 votes.
Can you read it?
Para 10 votes. The law with regard to eviction of the tenant from the suit premises on the ground of bona fide need of landlord is well settled. The need has to be real one rather than a mere desire to get the premises vacated. Landlord is the best judge to decide which of his property should be vacated for satisfying his particular need. The tenant has no role to dictating as to which premises the landlord should get vacated for his need alleged in the suit for eviction notice.
Yes, what do you want? Yes.
Uh, 2002 8 SCC page 765 para 5 votes. Thus, it is to be seen that under the said that if two or more premises, the landlord would choose which one would be preferable to him or her, and the tenant cannot question of such preference, Lordship. And second, in 2008.
Just a minute. In this particular case, the old lady said in evidence that she cannot climb, and therefore the vacant space was not suitable.
Yes.
Therefore, some explanation as to why the vacant space is not suitable has to come from them.
Yes. Next judgment is
Yes.
2005, 8 SCC, page 252, para 5 years.
Yes, please.
The counsel for the appellant submitted that in fact the plea of either starting a business or expanding in a Kalikat is nothing but sham, and it was also pointed out that some of the sons have multifarious activities are already established in some other business. One of the sons, that is respondent number 9, had already gone to United States of America and he had settled there. Therefore, need is not bona fide. We fail to appreciate that when two sons are and they are wanted to expand their business as Kalipat, that cannot be said that the
This
need
is
is.
so far as the finding of the court that Dan needed the premises. There is no doubt on that. But the point is alternative availability of alternative premises is the only question to be decided. That is the only question to be decided by this court, isn't it?
Yes. So far as adverse inference is concerned also.
Adverse inference on
Inference
what?
has been drawn against the because the Jain Viswas did not depose before the learned trial court also.
See, there are two distinct issues which were framed by the court. One was whether he at all required any premises, be it the sold premises or be it the vacant premises already available. So that adverse inference has been drawn because he has not come up with it. But here,
His father deposed.
that's
Satnarayana
right,
Vishwas
and let us
deposed.
assume for a moment that that's a sufficient. But the point is the alternative place that was available to you. There is no explanation as why didn't you want to go to the alternative
Para 11,
place?
12 or stated that supremacy is suited for the plaintiff lordship. It has been mentioned para 11 lordship.
Para 11 and 12 was the plea at the point of time when no other premises was available. But on account of subsequent development which had taken place when one of the premises got evicted, so that was a separate plea altogether. Certainly you have a choice. You have a choice. If you have 10 tenants, you have a choice which tenant to get evicted. There is no doubt on it. But when the defendant comes out with a plea that there is already a premises available, then at least you have to say that this is not suitable for you. There is neither any pleading nor any evidence that this is not suitable. There is nothing. Rather, you completely deny that this was available. You say that it was vacant since 1996. The finding is that it got vacated during the pendency only in the year 1998. And how do we get that? आपको क्या बोलना है?
Lordship, all the issues have been covered. I have to only add only one thing. That's Lordship, it is the constant pleading of the plaintiffs here in Lordship appellate that they were in need for opening of garment shop. Garment shop was available. They opted to again let it on increased Lordship rent. And Lordship, the second thing, that the person who is well qualified, who was urgent need of the shop, he even did not choose to come to the court to depose that what was his need. And even Your Lordship, the plaintiff has said that he did not feel necessity to bring him to the court. Otherwise, all these Lordship judgments are well reasoned and everything has been covered. No interference is required.
92 से चल रहा है. Nice.
कब खत्म होगा भगवान जाने. कब खत्म होगा भगवान.
हो जाएगा खत्म. आप क्या बचा खत्म. देखिए. Second appeal number 22 of 2003. This appeal has been filed against the judgment dated 18/9/2002 within bracket decree signed on 27/9/2002 bracket rules passed by learned additional district judge Roman for Bokaro entitled appeal number 12 of 2001 dismissing the appeal and confirming the judgment and decree judgment dated 14/3/2001 within bracket decree signed on 30/3/2001 passed by the second Munsif Chas entitled within bracket eviction bracket close suit number 6 of 1992, whereby the suit seeking eviction on ground of personal necessity was dismissed. This appeal was admitted for final hearing by order dated 14/1/2009 on the following substantial questions. the case of the plaintiff was that the defendant was inducted as monthly tenant in the suit premises by the husband of plaintiff number 1 and father of plaintiff number 3 to 5. However, the husband died on 14/1/1985. And since then, the plaintiff number 2 has been collecting the monthly rent from the defendant. The specific case of the plaintiff was that the suit premises was required for personal necessity for starting a ready-made garment business jointly with Vikas Chandra Vishwas, Jain Vishwas, Naren Narayan Ghosh, all of whom were unemployed and without any source of income. With respect to each of the persons, it was urged in the plaint that they were unemployed It was also stated that the defendant was asked to vacate the suit premises, but he refused to vacate. The defendant appeared in the suit and sought permission to contest the suit, which was granted, and ultimately he filed a witness. The claim of personal necessity was denied by the defendant. However, during the pendency of the suit, the 4 sons of the husband of the plaintiff number 1 were made party as plaintiff number 25. It was the case of the defendant that Jain Vishwas was a student and he was engaged in studies, and therefore there was no personal necessity for Jain Vishwas. Vikas Chandra Vishwas was working as daily passenger and carrying out his business of order supply, and therefore he was already occupied. And was earning well. And he used to take the assistance of Jain Vishwas in the same business. After the filing of the written statement, Vikas Chandra Vishwas had joined service in Messrs. Bokaro Steel Limited on 18/7/1994. the learned trial court, it further appears that a revision was preferred before the High Court under Section 14(8) of the BBC Act. And on account of subsequent development, the revision was allowed by the High Court by the order dated 4/9/1997, and the matter was sent for consideration of further development giving opportunity to the parties to file further evidence. The trial court judgment reveals that the following issues were framed by the learned. The issue number 6 is relevant for the purposes of the present case. The learned trial court, by considering the personal necessity with regard to Jain Vishwas, considered the evidences on record and was of the view that Sri Jain Vishwas would have been the best person to say as to whether he was studying or was sitting idle and unemployed. But the plaintiff failed to examine Jain Vishwas. The plea of availability of alternative accommodation was considered by the learned trial court, White paragraph 36. White paragraph 37. 36 and 37. The learned trial court recorded that the availability of the alternative accommodation was denied by the plaintiff. And however, the learned trial court, after considering the materials, came to a finding that during the pendency, one shop was vacated by Shyam Sundar Himka, and the same was let out to Priyag Kumar Mehta. in which they were running Messrs. PM Gardens. The learned trial court held that during the pendency, one shop of the plaintiff was vacated by Shri Shyam Sundar Hinka, and the same shop was let out to Shri Prayag Kumar Mehta. And in such circumstances, the court felt that the need of the plaintiff to start a new business and instead of utilizing the vacated premises, the same having been let out, the need was not bona fide. And ultimately, the suit was dismissed. So far as the learned first appellate court is concerned, two points were the points for determination by paragraph 13, which is as follows. So far as point number 1 is concerned, the case was primarily confined to the personal necessity of Jain Vishwas. The learned court clearly recorded that Jain Vishwas was not engaged in any studies since June 1997 for D.12.09.2025 course. And also recorded that plaintiffs at the time of institution of the suit claimed that the requirement for opening of shop of ready-made garments with 3 persons, but now taking into consideration the further development during the pendency of the suit, the requirement which existed then was in favor of the requirement which exists was only in connection with Jain Vishwas. The learned court recorded the evidence of PW1 and observed that the premises was now required for the business of Jain Vishwas, and the requirement of premises had not legally been eclipsed, and therefore it was to be considered as to whether there was a requirement of personal necessity under the BBC Act, and that it must be reasonable and bona fide. The learned court thereafter recorded the further evidence of the father of Jain Vishwas, who deposed in para 5 that his son had good academic career and was major, and he was desirous of entering into business, and NIIT course may be utilized in any type of business. But he also deposed that he did not feel it necessary to produce his son as a witness. The learned court recorded that it was not clear that what type of business Jain Vishwas was desirous to start, and as to whether the suit premises was fit for his business purpose or not. The court was also of the view that Jain Vishwas, for whom the business purpose the suit was required, could have deposed in the court about his prospective business and fitness of the suit premises. And consequently, the learned court took an adverse inference with regard to non-production of Jain Vishwas, non-examination of Jain Vishwas, and ultimately held that the court did not find that the requirement of the ground of personal necessity of plaintiff was reasonable and bona fide one, in the light of the further development in the case. With regard to point number 2, the learned first appellate court held that Syam Sundar Henka closed his shop in the year 1998. And on the same premises, a shop, Parivar Garments was, a new shop was opened. And there was a direct evidence of letting out the shop which stood vacated during the pendency of the case. The finding of the learned first appellate court with regard to point number 2 has been recorded in paragraph number 16 and 17. The learned counsel for the appellant, by referring to the first substantial question of law, has submitted that the learned courts have the learned courts, by holding that Jain Vishwas had no bona fide personal necessity of the suit premises, has primarily considered the fact that he was not examined in the suit. The learned counsel submits that the bona fide requirement of Jain Vishwas was fully supported by the evidence of the plaintiff witnesses, and therefore the courts were not justified in drawing adverse inference on account of non-examination of Jain Vishwas. He submits that on this point, the first substantial question of law is fit to be answered in favor of the appellant and against the respondents. With respect to the second substantial question of law, the learned counsel has submitted that the bona fide personal requirement has also been denied on the ground of availability of alternative premises which arose during the pendency of the case, which was decided against the plaintiff while deciding point number 2 by the learned first appellate court. And also by the learned trial court. The learned counsel submits that The Learned Counsel has referred to explanation 2 of section 11(1)(c) of Jharkhand Building within bracket Lease, Rent and Eviction Control Act 2000. Purana Act लगे ना BBC Act.
पुराना
BBC Act. BBC Act. To submit that, as per explanation 2, where there are 2 or more premises let out by the landlord, it is open to the landlord to choose which one would he prefer, and the tenant or the tenant shall not be allowed to question such a premise. He submits that it was the specific case of the plaintiff in the original plaint itself that they wanted the suit premises to start the business of garments, and therefore mere availability of alternative business or alternative premises would not have been a ground to refuse to decree the suit. The Learned Counsel has relied upon the following judgments. Bracket 2002, bracket close 8 SCC 765, para 5. To submit that if there are 2 or more premises, the landlord could choose which one would be preferable to him or her, and the tenant cannot question such a preference. There is also second bracket 2005, bracket close 8 SCC 252, para 5. To submit that इसको क्यों टाइप
छोड़ दिए
So bracket 2025 SCCR 270 passed by Honorable Supreme Court in the case of Kanhilan and Adia versus Mohammed Esas and others,
पाराटे
para 10. To submit that the law with regard to eviction of a tenant on suit premises on the ground of bona fide need of the landlord is well settled, and that the need has to be real, one, rather than a mere desire to get the premises evicted, and that landlord is the best judge to decide which of his property should be vacated for satisfying his particular need, and the tenant has no role in dictating as to which premises the landlord should get vacated for his needs alleged in the suit for eviction. The Learned Counsel submits that in the present case, the landlord had chosen the suit premises for the purposes of personal necessity, and the defendant tenant had no business to dictate the landlord with respect to the choice of the suit premises or of the premises in which the personal necessity would be best satisfied. He submits that merely because one of the premises was vacated during the pendency of the case, the same does not mean that it was suitable for the landlord for the purposes of business of garments. Okay? The Learned Counsel, appealing on behalf of the respondents while opposing the prayer, has submitted that the very fact that Jain Vishwas did not depose before the court and PW1 clearly stated that he would not bring Jain Vishwas to depose before the court, itself revealed that Jain Vishwas was not interested in running any business, and the plea of personal necessity was only a fluke to get the suit premises evicted. Plaintiff number 2 within bracket PW1, ध्यान रखेंगे है ना, PW1. The learned counsel submits that both the courts have taken adverse inference on account of non-examination of Jain Vishwas based on the materials on record, and there was no scope to come to a different finding with that effect, to that effect. It submits that non-examination of Jain Vishwas remained totally unexplained from the side of the plaintiffs. It is also submitted that Jain Vishwas was well qualified, and the reason for his non-examination is completely unknown.
One adjacent saw was
He has submitted that वो अभी आएंगे उसमें. So far as the availability of the alternative premises is concerned, the learned counsel submits that the written statement was amended with a clear averment that alternative and suitable accommodation was available for the plaintiff, which was adjacent to the shop premises, in as much as was available to the plaintiff, but the plaintiff, instead of using the same, has let out the alternative premises to another person
on enhanced rate.
at an enhanced rate. The learned counsel submits that it was never the case of the plaintiff, either in the plaint or in the evidence, that the alternative premises so available was not suitable for them. The learned counsel submits that pursuant to the amendment in the written statement, PW1 had appeared before the court on recall, and he had specifically stated about the alternative premises which became vacant during the pendency of the suit, and the fact that it was let out to one Prayag Metro, and this fact remains undisputed on the basis of materials and the findings on record. The learned counsel submits that in absence of any iota of denial on the part of the plaintiff that the alternative premises was not suitable for the business, the learned courts have rightfully come to a finding that the requirement of the plaintiff was not of the suit premises to which they were seeking eviction was not bona fide. That's all. Concluded. Judgment reserved. Post for judgment on. I'll put a date.
Public.
From date decided to 2nd April 182 of 1991.
अलग साइड आए नहीं।
कोई बात नहीं, किसी की जरूरत नहीं। जो लोग नहीं आते उनके बिना नहीं, उनके एब्सेंस में भी केस डिसाइड हो सकता है। आप हैं ना काफी।
The original plaintiff was admittedly a tenant.
50 adjournments हो चुका है इसमें, 54 adjournments हो चुका है, तो आज इसे सुन लो। Yes, yes.
I was not asking for adjournment. I was saying that there was a brief history that the original plaintiff was admittedly a tenant, and that has come in the agreement, in the plaint, and in the deposition of the plaintiff himself. He was a tenant. There is a one house, and a portion of that house is said to have been agreed to be sold to the plaintiff.
The plaintiff was tenant in the entire house,
No, in the portion of the house.
portion of
Portion of the house. वो आया जो चाय बेचते थे क्या करते थे?
and the agreement was for the entire house.
No, agreement was for that portion in which he was a tenant.
Agreement. What is the date of agreement?
The दे देंगे अभी डेट से हम खाली एक ब्रीफ हिस्ट्री खाली पहले दे रहे हैं, क्या हम डेट वाइज सारा चीज करेंगे। पहले एक पूरा बैकग्राउंड दे दें। द डिफेंडेंट नंबर 1 एंड डिफेंडेंट 2 and 3 में रिलेशनशिप ये है कि डिफेंडेंट नंबर 3 इज द सन ऑफ डिफेंडेंट नंबर 1 एंड पावर ऑफ अटॉर्नी होल्डर, एंड डिफेंडेंट नंबर 2 was a son-in-law. The son-in-law was also given a portion of the house just adjacent to the portion in which the plaintiff was a tenant. And in the rest of the portions, the heirs and successors of the defendant number 1 are residing. There is a common wall and common roof.
Defendant number 3 is the power of attorney of defendant number 1.
Number 1. But and he also accepted the notice on behalf of the defendant number 1, and the notices, it has come in the deposition that defendant number 1 resided in Durga Mandir, though his address in the first title portion is not in accordance with the addresses. It has been stated about Hazaribagh address and the Kokar address. The entire premises in which they were not there, entire premises was tenanted at that time. And only defendant number 3 was residing in one of the portions, being a son-in-law.
Defendant number 2 is son-in-law.
No. The plaintiff's case is that after the agreement on 11/10/1982 by Exhibit 2/1, the further extension of time was granted. That is a money receipt also. There are 3 questions of law which were framed. The third question is incidentally on the
By order
validity,
date.
validity of the receipt.
By order date.
Uh, Sixteen 2018. नहीं ये नहीं उसी डेट का है। आइए नंबर 3227 ऑफ ये डेट क्या है 16 68. Below you. Order number 17.
68. This is the additional question.
G.
Where are our other two?
जैसे इसको पहले खत्म कर लेते हैं उसके लाएंगे वहाँ.
ये तो substantial question of law तो बताइए compulsory.
First substantial question of law at the time of admission in the year 1992. 4/9/1992. थोड़ा सा क्लियरली स्पेल्ड आउट नहीं है. परवर्सिटी उसमें आना चाहिए था. क्लियरली स्पेल्ड आउट नहीं है.
ठीक है जो है सो.
During the course of argument हुजूर उसको
नहीं इसको refrain करो बस.
जी.
ऐसा नहीं है उसमें जो है you go by that. Whether the respondent was willing to perform as part of the contract or not. इतना ही.
नहीं उसके आगे भी है.
इसके आगे देखिए. Learned counsel for the applicant has also placed reliance on such and such.
In the circumstances, the appeal will be heard. I mean, normally,
Whether the plaintiff respondent was willing to perform as part of the contract or not is a complete question of law and a complete sentence.
क्योंकि इस अपील में एक सेट appellant और I am representing appellant number 1 and 5. Appellant number 2 and 6 are not in appearance. Appellant number 3 के तरफ से ये है brother.
I am representing with purchase.
Sane.
आप भी appellant हैं. Purchaser is appellant number.
3.
Suit was decreed.
Suit was decreed. We lost in appeal also.
Defendants are the appellants, right?
Defendant number 1 के अगेंस्ट में एक पार्टी हुआ था and that is written in the order sheet.
Ex parte against
The defendant number 1.
defendant number 1. Agreement किसके साथ हुआ था?
Agreement defendant number 1 के साथ हुआ था. Agreement का डेट है 18/9/92. It's exhibit 2.
18/9/92.
That is exhibit 2.
Agreement with उन्हीं के against में ex parte हुआ.
उन्हीं के अगेंस्ट में एक पार्टी हुआ क्योंकि उनका एड्रेस जो हम अभी दिखाएंगे हुजूर को उनका वो वहाँ रहते ही नहीं थे जहाँ पर तो ऑर्डर 6 का रूल 14A का 5 कहता है if the address of the defendant is not correct then the court should have made an inquiry about it. So it had come in the deposition कि वो दुर्गा मंदिर में रहते थे. प्लेंटिफ खुद ही कहे. He was knowing it. पता नहीं कैसे नोटिस सर्विस हुआ उनको. पता नहीं कैसे वो एग्रीमेंट किए. He was a retired teacher. इंटैक्ट हजारीबाग में रहते थे. जब रांची आते थे तो he was devout. He used to sleep in the
Defendant number 1 का नाम क्या है?
जुगल किशोर पाठक. The court says that since he had not appeared, no written statement was there. Therefore, what is stated in the agreement shall be deemed to be admitted. So there are rulings on the point that order 8 rule 10, even if the defendant doesn't appear, doesn't file a written statement, the plaintiff will have to prove the documents in accordance with law. I'll be addressing the court on this. In the agreement, it has been said that there were 6 witnesses जिनका नाम सिग्नेचर किया हुआ है, बट ना तो पेरेंटेज है, एग्रीमेंट काइंडली देखा जाए. एग्रीमेंट के लास्ट पेज में एक 2 सिग्नेचर है, बगल में आर.के. काबरा एंड आर.ए. पांडे लिखा हुआ है. These persons are neither examined इनका पेरेंटेज है ना इनका एड्रेस है. Learned appellate court ने एक डिसीजन पर रिलाई अपॉन किया है, जिसके बारे में ऑनरेबल सुप्रीम कोर्ट कहती है कि ये पर इंक्यूरियम डिसीजन है. I'll be addressing on that point also. That has come in the appellate courts. PW3 का पैरा 14 में आया है कि दुर्गा मंदिर में रहते. PW3 का पैरा 14 युगल किशोर पाठक दुर्गा मंदिर में रहते थे. The person who has written the agreement, he is the person who scribed the agreement. काशीनाथ साहू, advocate who has scribed the agreement. इसके बारे में कोर्ट ने कहा है कि चूंकि वो कह रहे हैं कि हमने एग्रीमेंट किया और लॉयर हैं, वो झूठ नहीं बोल सकते, बिलीव कर लेते हैं हम भी ये चीज. तो तब तक ये एड्रेस पर कभी नोटिस दिया? जरा काइंडली सीपीसी में जो प्रोविजन है अबाउट द एड्रेसेस व्हिच इज मेंशन्ड इन द प्लेन, उसके बारे में एकदम सीधा ये है कि if the address of the defendant has been falsely made, then the court should have stayed the entire proceeding, make an inquiry as to why this fictitious address was given. So, I was saying that the appellate court's judgment at para number 14 appellate judgment का पेज 9, पेज 8 and 9, पैरा 10. Appellate judgment 37. Appellate judgment का पैरा 10. Internal पेज 8 होगा, 8 and 9. इसमें it is correct. पढ़ें देखो मिला. It is a
हम साइलेंटली सर आपका नोट कर रहे हैं. सीधा एकदम कंटिन्यूअस आर्गुमेंट.
It is in para 10 मिला के नहीं खाली वो देखना.
हाँ.
It is incorrect to say that the plaintiff has not been pleased, pleaded readiness and willingness. AIR 1971 Supreme Court 1238. Readiness and willingness can be this is quoted. In Manjunath and Appa case of 2003 volume 10, it has been specifically stated about this decision, this very decision, that this was per incurium of an earlier decision in which the appendix A, form number 47 and 48 of the CPC was required to be necessarily pleaded and proved in a case of a specific performance or conduct. Let us kindly have a look at that appendix A, form number 47 and 48, that is Honorable Supreme Court says that this is necessary for the purpose of proving readiness and willingness. And that decision was overlooked while this 71 Supreme Court was relied upon in para 17 and 18 of that decision. जरा सा kindly पढ़ा दीजिए.
ये जजमेंट तो 1991 का हुआ है ना. टाइटल अपील का जजमेंट
71 का जो डिसीजन है वो 69 सुप्रीम कोर्ट के पर इंक्यूरियम है. पैरा 17 में देखा जाए ना. दीजिए तुम्हारे पिता. It refers to, in para 17 it says, the requirement to comply with the mandatory provisions of section 16C of Specific Relief Act came up for the consideration of this court in such and such case. The reference is 69 volume 2 SCC 539. Therefore the 71 Supreme Court के पहले का decision. And in that it was said in the third line, a suit for specific performance has to conform to the requirements prescribed under Form 47 and 48 of the first schedule of the Civil Procedure Code. In a suit for specific performance, it is incumbent for the plaintiff not only to set an agreement on the basis on which he sues, he must also go further to plead that he has applied the defendant specifically to perform the agreement pleaded by him. The defendant has not done. Kept that. यहाँ अब ये कहते हैं एग्जिबिट 3 के द्वारा उनको नोटिस दी गई. काइंडली हैव अ लुक एट इट. अब इसके बारे में नेक्स्ट पैराग्राफ में कहते हैं ऑनरेबल सुप्रीम कोर्ट ने चांडक का डिसीजन में पैरा 18 में कोट किया है, एंड दैट वाज ऑफ 68 सुप्रीम कोर्ट. एंड देयरआफ्टर द कोर्ट सेज अबाउट दिस 71 सुप्रीम कोर्ट, in para 18 says, without noticing the said decision. However, the bench in R.C. Chandak, that 71 Supreme Court is R.C. Chandak, without noticing that decision of 69, the court relied upon 71 Supreme Court and there is just no whisper about Form A, Form number 47 and 48 in the entire plain, entire judgment, nowhere. The place at which, now section 37, 38 of the Contract Act may kindly be seen, it says that the readiness and willingness has to be shown at a proper place. So once I know that this person resides somewhere else, he says, एग्जिबिट 3 देखा जाएगा. हम तो आज करने को ये भी मैं नहीं कर आज नहीं होगा शायद. हमको लगा सवेरे से हम 2-3 बार आए, हम इनको भी कह दिए कि आज हम करेंगे नहीं. मिला एग्जिबिट 3.
There is no averment in the plains of readiness and willingness.
नहीं, अभी तेरा शाम को एग्जिबिट 3 दिखाने दीजिए. एग्जिबिट 3 का सिग्नेचर का डेट है 3rd पेज में. एग्जिबिट 3 का एग्जिबिट 3
है यहीं पर.
हाँ, तो उसका लास्ट पेज देखा क्या, उसका सिग्नेचर का डेट क्या? तीस 11/82. और यहाँ जो कहते हैं कि उन्होंने रिसीव किया नोटिस फर्स्ट पेज पर, उसका भी डेट सिग्नेचर डेट वही. रजिस्ट्री से नोटिस जो भेजी गई, ये भेजी गई एमएल पाठक एडवोकेट, क्लाइंट नारायण प्रसाद शर्मा, योर क्लाइंट श्री राम किंकर पाठक. और कहते हैं इसी नोटिस के बारे में अपीलेट कोर्ट ने और ट्रायल कोर्ट ने जजमेंट में लिखा है, क्योंकि इन्होंने नोटिस दिया इसलिए इसको रेडीनेस एंड विलिंगनेस मानेंगे. रजिस्ट्री से नोटिस जाती है और सेम डे एक आदमी से रिसीव हो जाता है, और कहां पर रहता है उसके पास नोटिस भेजा नहीं गया. लास्ट पेज में देखा जाए नोटिस कहां भेजा गया.
नंबर 1 का क्या नाम है?
जुगल किशोर पाठक. जरा सा लास्ट पेज फिर एक बार काइंडली
इसको पर्सनल रिसीटर्स.
जी,
पर्सनल रिसीटर्स.
हाँ, पर्सनल रिसीट कैसे हो सकता है? आदमी कहाँ पर रहता है, दुर्गा मंदिर में रहता है, वो ये नोटिस भेज रहे हैं रजिस्ट्री करने. अभी तो कह रहे हैं हम रजिस्ट्री भेजे हैं, रजिस्ट्री एग्जिबिट 4 है. रजिस्ट्री
सिग्नेचर एग्जिबिटेड है.
हाँ, सिग्नेचर तो एग्जिबिट जब हम थे ही नहीं, तो जो भी एग्जिबिट हो. आप जरा सा उसको देखा जाए ना लास्ट पेज. लास्ट पेज में कॉपी टू श्री जुगल किशोर पाठक लिखा. They were knowing that this notice, that man will be moving here and there, I'll be giving it to him, और notice receive करके वो इनको हाथ में थमा देगा for the purpose of bringing it to the court as an evidence against him. जो हिंदी में लिखा हुआ है, हिंदी में सिग्नेचर किया हुआ है, और उसमें ये कहते हैं कि हमने रेडीनेस एंड विलिंगनेस के लिए सेक्शन 38 ऑफ द कॉन्ट्रैक्ट एक्ट को काइंडली है बोल. क्या है कॉन्ट्रैक्ट एक्ट? सेक्शन 9 ऑफ द स्पेसिफिक रिलीफ एक्ट सेज that all defenses available under the law of contract can be taken by the person, and that says that for the purpose of showing your willingness, you have to show that you have been at a proper place. There should be something. I met this Jugal Kishore Pathak at Durga Mandir. I went and gave it to him by hand. Something pleaded. The man was waiting. You are coming with a notice. Yes, 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 I will receive it. No, fishier. पोस्टल रिसिप्ट एग्जिबिट 4 है जरा उसको भी काइंडली देखें वो भी उल्टा डॉक्यूमेंट ना डेट पता चलता है ना कुछ पता चलता है कब रजिस्ट्री किया ये जिस दिन अब हम आते हैं एग्जिबिट 2/1 को है एग्जिबिट 3 के बारे में PW4 इन पैरा 6 और पैरा 18 में बोला PW4 के पैरा 6 में ये कहते हैं कि रजिस्ट्री ऑफिस में गए थे जुगल किशोर पाठक भाग गए कोई ब्लीडिंग नहीं है रजिस्ट्री का टिकट खरीद लिए थे उसको एग्जिबिट करा देना चाहिए था कहाँ कहाँ ढूंढते उनका तो एड्रेस दुर्गा मंदिर बोल रहा है एग्जिबिट 3
आप इतना गैप मत रखिए, कंटिन्यू योर आर्गुमेंट।
जी
अपना आर्गुमेंट कंटिन्यू रखिए, ऐसे बीच में गैप का जरूरत नहीं है, हम आपका सारा आर्गुमेंट रखा करते हैं। There is no requirement to give pauses to the argument.
जी
पॉज करने का जरूरत नहीं है, आप आर्ग्यू करिए अपना केस।
हमको लगा देख रही हैं।
नहीं, हम एकदम सब चीज देख भी रहे हैं, सब चीज नोट भी कर रहे हैं, आप जो जो चीज बोल रहे हैं सब चीज हम देख रहे हैं। यू जस्ट टेक इट फ्रॉम मी।
Para 11 of the trial court judgment. After considering the consideration of the oral and documentary evidence brought on record, I find that the plaintiff has paid rupees such and such on such and such date in which the agreement of sale was made in favor of the plaintiff, and again 1000 was paid on 1982, wide exhibit 2/1. Exhibit 2/1 has got two defects. Firstly, the date on which the exhibit 2/1 is signed, there is no order sheet to that effect. I have got the certified copy of the order sheet. (27/7/87) it is said to be exhibited. The exhibit में हाकिम का signature. And the order sheet of that date, I have got the certified copy. Kindly have a look at it, the way the things happen. ऑर्डर शीट का फाइल रिकॉर्ड हो गया। उसके बारे में हम जिस डेट पर हमने क्वेश्चन ऑफ लॉ सेकंड क्वेश्चन ऑफ लॉ बनवाया है, उसमें कोर्ट ने ऑब्जर्व किया है कि उस डेट का ऑर्डर शीट नहीं। काइंडली द ऑर्डर डेटेड ये 16/8 ना ये नहीं है कि अभी हम ये पॉइंट ले रहे हैं। उसमें ये लिखा हुआ था that is required to be stamped and required under entry in serial number 53 of schedule 1 of the Stamp Act, but admittedly not duly stamped, or to have been admitted not admitted in evidence, and further drawing the attention of the order sheet dated 27/7/1987 of the trial court, the learned court, counsel for the appellant submitted that the said exhibit 2/1 purportedly been marked as an exhibit on such and such date, but the said order sheet does not mention that on that date the exhibit 2/1 was marked. Exhibit accordingly the objections of the defendant such and such, उसको काइंडली देखा जाए वो ऑर्डर शीट लिखाया कैसे? 1/7/87 को लिखा गया कि 9/7/87 को पेश करें, मिला ऑर्डर शीट। 1/7/87 को लिखा गया कि 9/7/87 को पेश करें, 9/7/87 का कोई ऑर्डर शीट नहीं है। उसके बाद लिखा है पता नहीं 23/7 ये 28/7/87 आ गया और पुकार पर प्रतिवादी के सेशन से जब क्लियर हुई विद्वान अधिवक्ता से जाहिर होता है तो एग्जिबिट मार्क कहाँ होगा?
किसके एविडेंस पे एग्जिबिट मार्क?
ये
किसके एविडेंस पर ये एग्जिबिट मार्क?
बताएंगे। उस डॉक्यूमेंट को पहले मैं एग्जिबिट 2/1 को देखने के लिए कह रहा हूँ।
उस वो डॉक्यूमेंट एग्जिबिट 2/1 तो कोई तो प्रोड्यूस किया होगा ना बोला ना।
लिखते हैं
By
प्लेट
whose
में
evidence?
अब जरा सा
Now she is asking by whose evidence?
Yes. वो अगर उस दिन एग्जामिन हुआ है तो विल सी, नहीं हुआ है तो और सीरियस बात।
नहीं वो तो खैर हम उस पर जाएंगे बाद में। अभी पहले जो चीज दिखाना चाह रहे हैं एग्जिबिट 2/1 जो है वो मनी रिसिट है। जो पॉइंट वहां पर आया ये मनी रिसिट है, ये प्रॉपर्ली स्टैम्प नहीं है। ट्रायल कोर्ट के जज साहब को ये पॉइंट आउट किया गया, लेकिन उन्होंने कहा कि ये मनी रिसिट स्टैम्प है चाहे नहीं है, क्योंकि डिफेंडेंट 1 ने रिटन स्टेटमेंट नहीं फाइल किया, इसलिए हम इस ऑब्जेक्शन को नहीं सुने। I am referring, kindly have a look to the paragraph on which the trial court has rejected my contentions about this aspect of it.
Para 11.
उसमें मार्क नहीं है सर।
Which paragraph are you referring?
वो प्रिंट है लेजिबल नहीं, हमको पढ़ने में तो डिफिकल्टी हो रही है। जो है सर देख के बता रहे हैं, इतना साल केस पेंडिंग रहा तो भी तो भाग नहीं रहे ना, तो आए हैं यहाँ पर इसी के लिए। पैरा 10 the defendant has taken a plea that the written statement that the plaintiff got agreement for sale dated 18/9/92 exhibit 2 in his favor by practicing fraud such and such. The defendant have not produced any evidence. Besides, I have already stated above that the defendant number 1 has filed wakalat, defendant number 3 has filed wakalatnama for himself as well as a constituted agent of defendant number 1, and no written statement was filed by defendant 1. Ultimately, the same was fixed ex parte hearing against the defendant 1 on such and such date. Thus, the failure on the part of the defendant number 1 to file the written statement clearly goes on to show that the defendant number 1 admits the assertions made in the plaint. The execution of the sale such and such is not denied under the circumstances. The such and such is not made out. On that point, on order 8 rule 10, if a person doesn't file a written statement, the law laid down by the Honorable Supreme Court is there are 3 decisions on that. Say 2015 का वॉल्यूम दे दीजिए, 2007 का वॉल्यूम 16, 7 का वॉल्यूम 7 करीब पेज निकाल दीजिए, फोटोकॉपी दीजिए, फोटोकॉपी दीजिए। Para 5 onwards. Sorry, para 13. आप बैठिए ना, आप ज़्यादा और कंफ्यूज कर देते हो. In a case where the written statement is not filed, मिला देखो. The civil court has the jurisdiction to proceed on order 8 to 10. How the orders are not required to pass on a mechanical order. In exercise, the past conferred the aforementioned provision of law, quoting the decision of Balrej Taneja. The court in para 25-27 has said that in spite of admission of the fact having been made by a party to the suit, the court may still require the plaintiff to prove the fact which has been admitted by the plaintiff. This is also in consonance with the provision of section 58 of the Evidence Act. In 58 was quoted, no fact need be proved in any proceeding which parties thereto or their agents at the hearing before the hearing they agree to admit in writing with their hand under the rules such and such, provided that the court may in its discretion require the facts admitted to be proved by such and such. Now para 26 of that Balraj Taneja's case, the proviso to this section specifically says that a discretion to the court to require the facts admitted to be proved other than by such admission, the proviso corresponds to para 27. The court says, in view of the above, it is clear that the court at no stage can act blindly or mechanically while enabling the court to pronounce the judgment in a situation where no written statement is filed by the defendant. That is one aspect of the matter. Now, the second aspect of the matter is that the court says regarding the admissibility on the ground that no stamp duty was paid. Because that document 11/10/82 कॉपी ऑफ द प्लेंटिफ कहते हैं कि वो अनेक्स किए हैं. हमने रिकॉर्ड चेक किया था. कॉपी ऑफ द प्लेंट में वो पीछे तरफ वाला जो पेज है जिसमें कि एक कहते हैं कि इन्होंने सिग्नेचर किया, सिग्नेचर भी डिफरेंट है और उस पर वो था भी नहीं. उसी पैराग्राफ को पैटर्न को थोड़ा और आगे पढ़ दें, आगे पर पढ़ दें. It has also been contended on behalf of the defendants that the plaintiff has not paid rupees such and such on such and such date. My attention was drawn on the relevant evidence of PW4 and PW3. Advocate who is they stated that regarding the payment of such and such, and a receipt was prepaid and a revenue stamp. It was stated by the defendant that the plaintiff has not filed to prove the said receipt. Under the circumstance, it would be such and such was not paid. I have already stated above that the defendant number 1 to whom the money was paid has not denied the fact and not filed a written statement. He has also not come forward to depose. In this case, the contesting defendants are not competent to say that any payment was made on such and such date. Now, regarding the admissibility of a document, the ground that the document which is receipt, जो उस दिन का order entry number 53 of the Stamp Act says specifically, and on that point 2009 decision of the Supreme Court is there. 2009 volume 2. This is support of page 532. That was also in relation to the receipt. Receipt and stamp and all those, considering section 33 of the Indian Stamp Act. It was stated, it was held that if a document has not been properly stamped, it will not be looked into by any court for any purpose of evidence. And that was the question of law which was spread. आज मैंने पैर अब दर्द कर रहा हूँ, बहुत ज़्यादा तक खड़ा नहीं रह सकते, पैर सुन्न हो जाता है कभी कभी। मंडे को रखिए, ट्यूसडे को रखिए।
हम मंडे को तो रखेंगे, लेकिन फिर सुनेंगे पूरा।
हाँ,
और
सुनिए
आप
ना।
चूंकि आपको जजमेंट पढ़ा नहीं रहा है ठीक से, तो भाई अपने जूनियर को बोलिए, जब आप जजमेंट ही ठीक से नहीं पढ़ पाइएगा तो क्या बहस करिए?
फोटोकॉपी एकदम देखा जाए ना, फोटोकॉपी पढ़ा नहीं रहा।
तो इसके लिए हम लोग जिम्मेदार नहीं है ना।
नहीं, आप जिम्मेदार
आप
नहीं।
अपने जूनियर को बोलिए। इसका मतलब आप इम्प्यून ऑर्डर को बिना पढ़े बहस करिएगा तो कैसे चलेगा? कर
नहीं,
पाइएगा क्या?
हम कागज में नोट्स बनाए थे, हम उसी के आधार पर बात कर रहे हैं।
बिना पढ़े नोट्स बना लिए तो ये तो बहुत ही मतलब
नहीं, ये लोग पढ़ा था, बोल के पढ़ा था, हम नोट बनाए।
बोल के जब पढ़ा था तो बोलिए टाइप करवाने,
जी टाइप करवा रहे
वो करवाएंगे अपना टाइप।
हैं। हाँ जी।
उनका काम है, आपको लेजिबल कॉपी नहीं रहेगा, आप बीच बीच में अटक जाइएगा तो कैसे? हमारा भी मतलब फ्लो ऑफ थॉट डिस्ट्रक्ट हो जाता है ना।
सही बात।
सर उनको उनके साथ बैठ के नोट्स बना लीजिए, मंडे को बहस करिए, पूरा सुनेंगे।
2:15 बजे रखा जाए।
2:15 बजे दूसरा बेंच, 2:15 बजे बेंचेस
तो मंगल को रखिए, तो फिर नहीं कर पाएंगे ना। फर्स्ट हाफ में हमको ऑलरेडी फिक्स मैटर।
नहीं कर पाइएगा तो उसमें तो हम कुछ कर नहीं सकते।
मंगल-
सेकंड हाफ में दूसरा बेंच है, आप किसी दिन आइए।
मंगल को बुध
मंगल को आ जाइए, जब आपको मर्जी आ जाइए। 10:30 बजे से बहस शुरू करिए और 1:30 बजे तक खत्म करिए। बहुत तैयार हैं। बैठ के बहस करना है तो बैठ के भी कर सकते हैं। बैठ सुनना अगर हो जा रहा है आपको, कोई मेडिकल रीजन होगा तो आप बैठ के भी बहस कर सकते हैं, वो कोई इशू नहीं है। लेकिन कंटिन्यूटी में करिए, ऐसे रुक के मत करिए। थोड़ा नोट्स बना लीजिए। आप तो पहले भी नोट्स दिए हैं कोर्ट को, ऐसा तो नहीं है अच्छा नोट्स बना के देते हैं, ऐसा नहीं। कुछ तैयारी कर लेंगे तो कोर्ट का समय बचेगा। नहीं तो ऐसे
वो सब
तो
सही है। अभी कुछ दिनों से पैर में झुंझुनी ज्यादा हो जा रहा है।
नहीं तो बैठ के भी कर सकते हैं, ऐसा कोई दिक्कत नहीं।
नहीं,
ऑनलाइन भी कर सकते हैं, उसमें क्या?
सर्टेन विटामिन का कुछ डेफिशिएंसी है।
आप ऑनलाइन भी कर सकते हैं। You want to do it online, there is no problem. ठीक है, ट्यूसडे को 10:30 बजे रखते हैं। 10:30
10:30 में नहीं हो पाएगा, नहीं कर पाएंगे। 10:30 हम गाड़ी चला करके उतना दूर से आते हैं, एकदम एग्जॉस्ट हो जाते हैं।
तो फिर कुछ ऐसा करिए कि कोर्ट का टाइमिंग चेंज हो जाए।
12 बजे 11
ऐसे नहीं होगा ना, 12 बजे होगा तो आप 1:30 बजे तक कंप्लीट नहीं होगा, तो ये कहानी कैसे?
नहीं, हम कंप्लीट कर देंगे। हम
मेडिकल
कर देंगे।
You will take 1 hour. नोट्स बना के लेके आइए, कम से कम इतना तो कर सकते हैं कोर्ट के लिए।
हाँ,
ठीक है, नोट्स बना के लेके आइएगा तो 1 घंटा भी नहीं
नहीं
लगेगा।
वो कुछ नहीं लगेगा, एकदम कुछ है ही नहीं। द फैक्ट ये है कि जो दामाद जी हैं उनको बगल वाला मकान दिया हुआ था। दामाद जी बोलते हैं कि हमको ही बेच दीजिए, और वो कह रहे हैं कि हमको बेच दिए हैं पावर ऑफ अटर्नी होल्डर। कुछ जो ऐसा हुआ है कि वो आदमी बूढ़ा अपीयर नहीं कर सके, काफी बूढ़ा आदमी था, मंदिर में जाकर सोता था, ये प्लेंटिफ भी जानते हैं। तो वो आदमी को एग्रीमेंट करा लिए, चाय पकौड़ी खिला के बूढ़ा।
सर जो मेहनत कर रहे हैं मैम,
ये कब का सूट है?
86 कब का है?
86 में ये बूढ़े थे क्या वो?
जी रिटायर तो 57 में किए हैं।
और अभी तक जीवित हैं।
नहीं मर चुके हैं लोग तो अपील के टाइम ही मर गए, अपील फाइल हुआ 3-4 दिन के अंदर में मर गए।
हुजूर हमारे सीनियर जो मेहनत कर रहे हैं इनका कुछ होना नहीं है, या तो दामाद का होना है या तो हमारा होना है, बट स्टिल ही इज वर्किंग हार्ड।
अभी नहीं तीसरे दामाद का भी नहीं होना, किसी और का नहीं होना। एक और चीज नॉलेज में आया अभी ये पूरे डेट को इन्होंने असाइनमेंट कर दिया एक थर्ड पार्टी।
ठीक है, that is a
नहीं
different
ठीक है, उसको 3 लाख रुपए में बेच दिए हैं। वो जो असाइनी है वो मेरे पास आकर के हमको रोज हड़काता है कि हम जो है निकाल देंगे।
Second appeal number 182 of 1991 written bracket R. The arguments of the present case has commenced. Would I read it to move? The learned counsel for the appellant has submitted that the substantial question of law was initially framed on 4/9/1992, and thereafter an additional substantial question of law has been framed on 16/8/2018. He has submitted that the plaintiff was a tenant in a portion of the house, and an agreement for sale was entered into between the landlord and the tenant, and the tenant continued in possession of the property. He has further submitted that the agreement is dated
मानवाद हम नहीं लिखे हैं।
नहीं है।
वो बिल्डिंग गिर गया है, छत गिरा हुआ खाली दीवार।
There was an agreement between the
अब
landlord
वो तो
and
बेच
the
करके
tenant.
चले गए, गुजरात तो मर गए हैं। उसके बाद
There was an agreement between the landlord and the tenant.
असाइनी को दे दिए हैं।
That is correct? नहीं, वो भी नहीं आया फैक्ट में. He was tenant, ये भी नहीं आया.
क्या?
The
टेनेंट है तो आया।
plaintiff was a tenant.
यस टेनेंट और पोजीशन में टेनेंट ही था, उसी को असाइन, उसी को एग्रीमेंट।
Agreement.
हाँ बस इतना ही।
An agreement was entered into between the landlord and tenant with respect to the suit property. And the agreement was entered into with defendant number 1. The agreement is dated 18/9/1992. He has submitted that defendant number 1 was proceeded ex parte. The learned counsel has further submitted that in spite of the fact that the proceeding was ex parte, the suit cannot be mechanically decreed, and the provisions of Rule 8, Order 8, Rule 10 of CPC was required to be followed. He has further submitted that, and for this purpose, he has relied upon the judgment passed by the Honorable Supreme Court. वो judgment दिखाइए. Reported in bracket 2015 bracket close 12 SCC 403 para 13. The learned counsel has also submitted that the defendant number 1 was used to reside at some other place and not at the given address. And for that purpose, he has referred to the evidence of PW3 para 14, who said that that the defendant number 1 used to reside in Durga Mandir. PW3 was the scribe of the agreement, namely Kashinath Sahu, who was an advocate. The learned counsel submits that if the address has been wrongly made in the claim, then an inquiry is required to be conducted. But no such inquiry was done, and the suit proceeded ex parte against defendant number 1. The learned counsel has submitted that defendant number 3 is the son of defendant number 1, and also the power of attorney holder of defendant number 1 and defendant number 2 was the son-in-law.
And number 3 is grandson of
Grandson. Defendant number 3 is grandson of defendant number 1.
अभी अब हो गए हैं उस वक्त
Defendant number 2 is the son-in-law.
son.
And who are you?
Yes, I am representing son-in-law. I am purchaser. In
And
my
who
favor,
is
this
the
agreement
who is the
registered.
purchaser of the suit property?
Yes.
from the
That has been
from the grandson.
no grandson
Just a
power
moment.
of the power of
Grandson
attorney.
Just a moment. He is
Grandson
the purchaser of the suit property. Correct?
Yes.
from the grandson power of attorneyhood of the dependent number 1.
The learned counsel submits that in that as per the provision of as provided under Form 47 and 48 in Appendix A of the CPC, the necessary pleadings for specific performance in the present case has not been taken by the plaintiff. He has referred to the judgment passed by the Honorable Supreme Court reported in bracket 2003 bracket close 10 SCC 390 para 15 to 17 for this purpose. The learned counsel has submitted that Exhibit 2/1 was marked as exhibit on 27/7/87, but there is no order sheet showing that exhibit 2/1 was marked on that day. He has submitted that at the time of framing substantial question of law on 16/8/2018, this aspect of the matter was duly pointed out. The learned counsel then referred to the judgment passed by the Honorable Supreme Court reported in bracket 2009 bracket 2 SCC 532 to submit that in absence of stamp on exhibit 2/1, the same was inadmissible in evidence. He has referred to entry 53 of the Stamp Act and submits that this has to be read with section 33 of the Indian Stamp Act. That's all. This is what you have submitted today. Tell me. The matter has remained inconclusive. At the request of the learned counsel for the appellant, post this case for further hearing on Tuesday to be taken up at 12 o'clock. During the course of hearing, the learned counsel has also submitted that he shall prepare a short note so that the matter is taken up. The matter is concluded at the earliest. Pardon?